Good morning. Will the Committee on Zoning please come to order? At this time, I'd like to welcome committee members Cordero, Esther Zer, Kiaina, and Wire. Also in the gallery is Council Member Tupola and Chair Waters. I would also like to welcome Council Member DeSantos Tam, who is now participating remotely by video conference. Council Member Tam, DeSantos Tam, in accordance with Section 92-3.7 Hawaii Revised Statute, please identify each person who is with you at your location.
There's nobody with me.
Okay, great. Pursuant to Section 92-3.7, the Hawaii Revised Statutes, this meeting will be conducted as a remote meeting by interactive conference technology with the following procedures in effect for the meeting. Members of the public will be allowed to provide oral testimony on all items on the agenda in two ways: remotely and in person in the council chamber. Remote and in-person oral testimony will be allowed when the agenda item is taken up. Before testifying, each person shall state their name. Each speaker may not have anyone else read their statement and is limited to a 1-minute presentation on each item. All persons who have registered to testify remotely by video conference or phone will be called upon first. When your name is called, please monitor your screen and activate your audio feed when prompted. For those who are joining us by telephone only, I will identify you by the last 3 digits of your phone number. When your number is called, please press *6 to unmute yourself when prompted. I will then give persons who have not registered an opportunity to offer testimony. Please utilize the raise a hand feature in Zoom to be called upon. Some friendly reminders and tips. Video conference from a quiet location if possible. If you're also watching the proceedings on Olelo, please mute your television at the time you're called to testify. When the timer on the screen reaches 0, please conclude your remarks promptly. Once all the remote testifiers have testified, I will proceed to an in-person testimony in the council chamber. Persons who have not registered will be given an opportunity to speak following the oral testimonies of the registered speakers. Hawaii Revised Statute Section 92-3.7 requires all votes at remote meetings to be conducted by a roll call unless unanimous. Therefore, I will first call for objections, and if there are any, I will then call for a roll call vote. For those council members participating from outside the council chamber, in accordance with Hawaii Revised Statutes 92-3.7, the meeting will automatically recess if we lose audio-visual contact with you and cannot reconvene until we reestablish contact. Therefore, please announce beforehand if you will be voluntarily signing out of the meeting. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described on the posted agenda. As a courtesy to all of us, please turn off all cell phones. Okay, let's move on to agenda number 1, Bill 52 of 2023. This bill relates to large dwellings. Members, we have posted to the agenda a proposed committee draft 1 version of the bill. For your information, a summary of the amendments is listed on the agenda. The committee draft 1 version of the bill would move the enhanced fines for land use ordinance violations relating to large detached dwellings from LUO Article 3 relating to zoning districts to LUO Article 2 relating to administrative enforcement. The current fines are up to $5,000 in initial fine and up to $5,000 per day for each day the violations persist. The bill would increase these fines up to $25,000 initial fine and up to $10,000 per day for each day the violation persists. Members, for your information, a written request from DPP for a 120-day extension of time is available online for Departmental Communication 288 of 2024. At this time, may we call upon Ms. Director Apuna.
Aloha, Chair, members of the committee, Dawn Apuna, DPP. So we are supportive of the proposed CD1 for this bill, and we think it's an important deterrent to those who continue to believe they can violate the monster homes ordinances. I'm available for any questions.
Okay, members, any questions for the director in increasing the fine? Okay, if there is none, thank you very much. At this point in time, we will now proceed with the remote testimony. Madam Clerk, do we have any remote testifiers?
Chair, there are none.
Okay, thank you very much. Clerks, is there anyone else standing by remotely to testify? If so, please use the raise hand feature in Zoom. When I call your name, please follow the prompt and unmute yourself.
Chair, there are none.
Thank you very much. At this time, let's move on to the in-person testimony. We will now proceed with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Yes, Chair, we have one standing by.
Okay, Mr. Monaco, please.
James C. Monaco, senior concerned parent, grandparent, great grandparent. You know, I don't know if you folks know it, but in Waianae, we already have monster homes. It's been there for about 5 years already. And, you know, it's not built for the families there. We have a lot of homeless. And it's been open for all these years. And how do we get to use it? Yeah, I don't know how do we get to use it. But anyway, I don't think it was built for the homeless. None of the families in Waianae own it. These are all investors. So I think what they're doing is they're really waiting to have these bills passed. And they're going to open it up. And if we look at the next bill that we have here, it's relating to bed and breakfasts and transit vacation units. So what's going to happen is that I think Waianae is going to be open up to these bed and breakfasts and transit units. And what I'm afraid of is that the Waianae people is going to be affected because across the street is where all the ulu fishermen fish across from all of these units. And it's stretched from Nanakuli to Makaha. And if you know, you cannot catch ulua when people go across the street to go swimming. And that's going to affect all of us. So please take that into consideration because we've been fishing there for years. Excuse me. We've been fishing there for years. And if these people start coming across the street for swimming, you know what happens. Fishing and swimming doesn't mix. So please protect that. Thank you.
Thank you very much for your
Any
strong
question?
support of the measure.
No.
Thank you.
Thank
Okay, if there is anyone else in the conference council chambers who would like to testify, please come forward at this point in time. If there is none, members who are in discussion. It's basically more of a house cleaning measure.
Yeah.
Yes, Council Member
Thank-
Kiaina.
Thank you, Chair. I strongly support this measure, and I understand why you, I guess, had separated the, your CD1 addresses those who construct monster homes as opposed to those supplying incorrect information. I just want to make sure that DPP still is able to deter folks from, or at least, how do you say it, make sure that they can catch those who supply incorrect information. No sense in having a monster home built based on that information and they not be penalized in some fashion. So I hope that that area is strengthened. The Kailua Neighborhood Board on November 2nd, 2023, strongly endorsed this measure, and I think that it will be an effective deterrent to the building of monster homes. So just thank you for your leadership on this.
Okay, thank you. Any further discussion, members? If not, the chair would like to recommend that Bill 52 be amended to the posted committee draft 1. Any discussion, objections, or reservations? Hearing none, the bill has been amended to the committee draft 1. The chair then recommends that Bill 52 of 2023, committee draft 1, be reported out for passage on second reading and scheduling of a public hearing on the committee draft 1. Any discussion, objections, or reservations? Hearing none, so ordered. The chair notes that the time needed to consider Bill 52 of 2023 may exceed the current deadline for council action. The chair therefore recommends that the bill be granted a 120-day extension of time pursuant to the request from the Department of Planning and Permitting in the Department of Communication. That was 288 of 2024. Is there any discussion on the extension? Any objections or reservations? Hearing none, so ordered. Thank you very much. Let's move on to Bill 53. Okay. Moving on to item agenda number 2, Bill 53 of 2023. This bill relates to the registration requirements for bed and breakfast homes and transient vacation units. Members, we have posted to the agenda a committee draft 1 version of the bill that I had proposed, and for your information, a summary of the amendments is listed on the agenda. Members, we have also distributed a hand-carried committee draft 1 version of the bill proposed by Councilmember Tupola. I will defer to Councilmember Tupola to explain her committee draft 1, then I will explain the committee draft 1 that I had proposed.
Thank you so much, Chair. So for the committee draft I proposed, I'm just going to narrow in on number 4. So for Councilmember Say's and mine, they're actually very, very similar, except for one small part. So I'm just going to outline that part, and then we'll leave it at that. So on number 4, we're going back and forth between whether or not the homeowners association should be able to produce a letter that verifies that they are permitted to be there. And we all know that it's only in the resort zone. So I just have Kolina and a little part of Makaha that has this. But I suggested that it be 1 year because every document you request from the homeowners association, they're going to charge you per document. So that was the difference, 6 months to 1 year. And the second thing that I propose, also dealing with number 4 and council member says, is that if they turn in the bylaws that also indicate that it is permitted, that could also be an acceptable document. Again, that is back to the case where every time you request something separate from the association, you get charged for it. And a lot of the guys who are legally running this in Colina, they already pay the $1,000 registration, they pay the $300 fee to register, to do the zoning verification, and they pay $300 for the title report. So I think it's reasonable to allow for a letter within a year. I also think it's reasonable that if it states in their bylaws that that area is zoned and permitted, that could be an acceptable document. Thank you so much, Chair.
Thank you. Members, any questions? Go, Councilmember Cordero.
Chair, I was wondering if we could be directed to which page and which number clause we're looking at. Sorry.
No problem. Let's go to ROH 21-5.730, letter B, number 1, letter F.
Okay, thank you very much.
No problem.
Okay. That was the council members' amendments. At this time, the chair would like to share with the council members the committee draft 1 version of the bill that I had proposed would streamline the bed and breakfast and transit vacation unit registration and registration renewal process and allow for additional types of supporting documents to support the evidence compliance with B&Bs and TVU requirements. In addition to the required $1 million per occurrence in commercial general liability insurance coverage, the committee draft 1 allows for homeowners insurance with business liability coverage in the same minimum amount. Additional homeowners insurance umbrella coverage to meet the minimum $1 million in homeowners insurance business liability coverage is also acceptable. The registration and registration renewal fee amounts have been moved from Land Use Ordinance Article 5 relating to special use development standards to the revised ordinance of Honolulu Chapter 6 relating to funds, fees, and loan programs. So at this point in time, members, for your information, the written request from DPP for a 120-day extension of time is available online as Departmental Communication number 287. Okay, so any questions for Director Apuna or for the chair at this point, the amendments? Yes, please.
Chair, normally in their letter, it states that, they need more time for the extension. And so is it the same type of request for the extension?
Yes.
Okay.
And to give the general public and the members an opportunity to see the 2 drafts of the committee draft 1s that are being proposed. Okay, Director Apuna, we'll call upon you now.
Thank you, Chair. So the proposed CD1, I think we have some comments. First, I believe that the original draft had allowed a lot of the documents for registration to be provided upon request by the department, and we actually prefer that to still requiring all these documents as part of registration because it is a very intense resource necessary job to go through each application and check all of the different documents. So we would prefer going back to the original requirement to, or in the bill to allow these documents to be only upon request. Secondly, with regard to the HOA or the association's requirements on STRs, we appreciate Councilmember Tupola's suggestion of the 1 year current status of that policy. I think a date is, that's what we struggle with, is identifying what the most current policy is. We just want to be able to have the HOA provide, maybe even on request, like what is the current policy, and maybe it's just a more direct requirement of the HOA versus the applicant. I think we're still kind of discussing it, what would make the most sense for both the applicant, for DPP, et cetera. So we're open to more discussion on that. And then there is reference in the bill that when there is a change in ownership, that there needs to be a new registration, and it also refers to a change of operator, but we would like to limit that change to just the owner of the property. We don't believe that a change in operator should create the new registration. And then there's the amendment for the deadline to renew registration to be 1 month after expiration. We would request that rather than 1 month prior that the registration be submitted or renewal, that we give them a grace period for 1 month after expiration.
Okay.
And so-
Director Apuna?
Yes.
With the drafts that you have been proposing, can you make reference to the section of the proposed bill that we have before us, Bill 53? Meaning, these are the areas that you like to change. So if you would go, page by page or section by section, that would be very beneficial for the members and the audience.
Okay, sure. I apologize for that. So the First Amendment with regard to requiring documents upon request rather than
Yes.
at registration. Let's see. So this is to ROH section 21-5.730B1, initial registration.
Okay, yes.
And then the second one with regard to the HOA, that is with regard to ROH section 21-5.730B1F as in Frank.
Okay, got it.
And then the third amendment regarding taking out the operator is ROH section 21-5.730B8.
Okay,
And then,
got it.
okay, and then finally, with regard to the grace period that we're asking for registration and renewal, is ROH section 21-5.730B2.
Okay. Okay, members, any questions for the director? Councilmember Tupola, please.
Thank you so much, Chair. Aloha, Director. Thanks for your work on this. I would say that I've looked at this for a while since the passage of Bill 41 to see how we can encourage more registration so that you're aware of it. Just for your notes, ROH 21-5.730B2 also says DPP upon request. B2A says DPP upon request. B2B says request. So I think I can go through and work with Chair's office, but
Yeah.
I kind of agree, that it's going to be very hard, one, for the applicant process, but also for you guys to constantly reach out and ask for documents. Everybody that I've talked to is fine as long as it's clear what to submit upon registration. I think that would clarify everything if everything was just due upon registration. Secondly, I guess for my suggestion on the homeowners being able to submit their bylaws, I thought it would also be helpful for your department to know what the homeowners association is saying. So instead of going applicant by applicant and saying, "Oh, you can have this and you can't," you should probably get to know what the whole homeowners association verbiage is. That way that verbiage is clear from association to association what they are allowing to be permitted, and just make sure that it aligns with the law. So that's why I thought it could also be an acceptable document and then help to kind of streamline our process as well. Lastly, I just want to say that I also think everyone that I have talked to is in agreement that upon a change of ownership that there should be another starting point so that you guys can have the new person be aware of all of the rules and regulations that are associated with what they need to do to comply with the law. So I didn't really ask you a question. I was just telling you that, thank you for your continued work on this.
No, thank you. And we agree with all of those points. I think it's important after a year and a half of the registration, we've learned a lot. And as far as like upon request, that's very important because then we can shift our focus on the enforcement. If you're in the resort areas, we presume that you're able to do these things, just pay the fee and let us know. And then we can be more focused on enforcing against the illegal STRs.
Well, and I think that's what we want, right, is to shift all of our resources away from a really laborious registration process and into an enforcement process. So thank you for that. Thank you, Chair.
Okay, members, any other questions? Thank you. Councilmember Cordero, followed by Wire.
Okay, thank you, Chair. Hi, Director. I just wanted to know what is required when the HOA is communicated with already.
So I think that it's directly with the applicant. So the applicant is supposed to be able to provide information that they're allowed to have the SCR, with their unit, basically. And so they could be, it might be in their bylaws, it might not, because normally it's when it's not allowed, I think, is when there's documentation. So they wouldn't put that, obviously, if they're trying to register for one. So I think there is some difficulty. But yeah, if they can present at least the HOA documents that don't say that it's not allowed, that is, yeah. And I have Lena here who can provide more details.
Good morning, Chair and committee members. My name is Lena Pomsuan, DPP Staff Planner. So for the Homeowners Association right now, it would be the bylaws, confirmation from the Homeowners Association that it's allowed. So for us at the city, right, we are giving STRs for the resort district and certain apartment districts based on the maps that were approved in Ordinance 22-7. So we have found that with the different kind of applicants, they do have sometimes a hard time with that requirement itself, and it's also difficult for us in terms of enforcement, since that is something that kind of overlays on top of our city requirements. So we think a letter is sufficient enough. We're open to keeping the bylaws as well, as long as it's been given the okay.
Okay, thank you. And I appreciate you sharing the different points, especially what is allowed in their bylaws, as opposed, and along with the letter being sufficient enough. But of course, it's also kind of piecemeal, right, per applicant, and making the applicant the intermediary between DPP and, I guess, the HOA, right? And so are you looking at different system changes, I guess, just to make it, as Councilmember Tupola said, less laborious?
It is quite difficult for us because there are so many different owner and homeowners associations that, they do their own type of strategy or policy. So it's really up to the owner to contact them. When it is an area where there are a lot of short-term rentals, it is a lot easier. We do see owner associations that are really helpful for a registration, where they already provide these documents, provide the floor plans that are required. So it's a collaborative effort for sure.
Thank you very much. I appreciate it. Thank you, Chair.
Thank you very much. Councilmember Wire?
Thank you, Chair. Yeah, and I'm kind of following up on the same line of questioning. I was just curious if you could elaborate on just the issues that have arisen with meeting the requirement for the homeowner association criteria. And the reason I'm asking is I'm just kind of wondering if it sounds like there were challenges, but also just in terms of the interface between community members and maybe their HOA. I'm just wondering if the city's been pulled into disputes or disagreements, and I don't know, just in terms of enforcing private contracts between HOAs and homeowners, like in our experience on regards to other issues in the community, like just gets kind of dicey, especially if folks decide they're gonna say sue their HOA, which I mean, I know I have HOAs that have pending litigation between homeowners and the HOA or, you know, the outgoing board and the new board.
We haven't been pulled up into any, you know, disputes between owners and homeowners associations. It's more so they are working it out with each other. If we see the documents that they've submitted and it says that the association doesn't allow a short-term rental use, then we'll revoke it or deny the application. So yeah, we're more toward the end part of the review versus anything like that.
Okay. Are there any other permit situations, and maybe this is for director, where private contracts are factored into a permit decision, or whether it's granted or not? I'm just curious.
Yeah, I mean, we try to stay out of any kind of relationship, contractual or other, between two private entities, and that's basically standard. So, but I think in this case, maybe if there were a required registry by the HOAs, that they let us know what is the current policy, that would really help for, I think, both DPP and the applicants. So if they continue to update it, and if it's not, you know, if it becomes an issue and they don't provide the latest, then we can look at it more closely. But that is the main issue, is that we're trying to ask something of the applicant who is relying on the HOA to provide that confirmation.
Yeah, and then, I mean, I guess because I'm looking at the proposed changes in the original version would be just a letter, and that's kind of the discussion versus the bylaws. And so in that way, it would be left up to the current disposition of the board and maybe their feelings versus maybe the actual underlying legal status of the bylaws or a particular unit. Or do you think that's a valid concern, or do you think we can remedy that?
Well, I think part of it also is that those boards, they only meet at certain times and take up certain agenda items when they believe it's necessary. So it can put the applicant in limbo. So if we just understand the basic policy for their property, and maybe we require them to directly provide it to DPP, I think that's a fair way to kind of gauge what the land use is for that property, and then we can process probably faster and better.
Okay. Well, thank you, Director. Thank you, Chair.
Okay, any questions, members? The chair would have a couple questions, Director. It's just a question in regards to data upon the request from DPP. How does one initiate that request to the HOAs or private owners? Is it going to be a specific audit of a particular association? Will it be individuals within the association? Will it be private? For the members, the measure that that is before us is that DPP is requesting that the filing of all information will not be needed until upon request if a complaint is filed. Are you folks comfortable with that? Andrea, Councilmember Tupola?
Yeah, I guess so. You're proposing that if there's a complaint, that DPP can make the request. I think from the individuals that I've talked to that are legally operating, They just want to comply. They don't want to be fined. They don't want to be accused of doing something wrong. And so from the get, they want to turn in all their documents. Everyone I've talked to said, I want to know what the list is. I will turn in everything. So I think that will then free up Dawn's team so that they can actually go and do enforcement on illegal ones so that you already know, okay, these ones are in the clear. So that's just my personal thought.
Good point. And for Councilmember Wire, since you have these type of short-term vacation rentals along with the B&Bs, what are your thoughts because of the area that you do represent?
Yeah, and my apologies, Chair, but could you just repeat the original question?
The original question is that, are you folks comfortable that whatever filings is done, they're not going to check it until there is a request from a complainant? Right? They'll file it.
No,
the data, and all of us will not know if the data is correct or not. Also, but we're going on trust. Am I correct for the applicants?
So just to clarify, since I think it's just 3 of us that have it in our districts, I think what Councilmember Say's version does is saying we're going to trust the applicants, and if there's a problem, DPP can request it, whereby they get all the information. What I'm suggesting, and I think what the director is suggesting, is that upon registering, turn in everything. So turn in everything just so that we're in the clear, we have all your paperwork, and then it doesn't have to be by request. And that includes everything from the title to the bylaws to the, to the qualifications to the ownership documents. So my preference is to do the first part, but again, it's a policy decision. So I think it's also whatever is going to not deplete resources from DPP is my thought.
Yeah. And
Can I just clarify? So actually, we would want to just have the law state what they should have, all these documents. They should have everything. They should be in compliance. But we're not going to, you don't have to submit it upon registration or renewal, only upon request by DPP. And so that would, it is kind of we assume that you're compliant, you're within the zone, and you're going to pay your registration. We assume you're going to do all these things, but when we have an issue or if we want to do an audit, then we might ask for that information, or that's when we would like to ask for it. But as long as I think if it's clear in the law that you should have all these documents ready at any time, that would be sufficient for us.
Okay.
Yeah.
Well, so given that, and I'm just basing off the discussion earlier, you're okay with the language it is by having available for inspection then?
Yes.
Okay.
Yeah.
Yeah, I think ultimately whatever lessens the burden on DPP would be my preference, so they can, focus on enforcement.
Okay, great, thank you. Okay, Vice Chair DeSantos Tam. Tyler, are you there?
Thank you, Chair.
You're welcome.
I wanted to ask the department, could you walk us through the timeline of you getting a complaint and being able to do an investigation? Because I think this discussion, while it relies on trust, also relies on the department's ability to get this documentation in a timely way. If somebody's going to be operating in illegal or something outside of the law, they can keep on doing it while DPP gets its documents together and does its investigation. And I think for the neighbors, that would be very frustrating. So could you walk us through that timeline? I want to make sure it's a reasonable timeline.
Thank you, Council Member. So yes, when we get a complaint, I think it would be as soon as the inspector receives the complaint that he could right then ask the owner-operator to provide that information. And I would think the burden is on them to provide it immediately. Otherwise, I think we have the authority to start fines, et cetera. I think that's what's important. It's not that they don't have to have that information, or that they should have it upon registration, and they should just be able to provide it when we ask. But we're just eliminating the burden on both to upload it, for DPP to go through it. I think it's just a much more efficient way of doing it. But yes, I think it's pretty immediate that we would ask for that information if there is an investigation.
Vice Chair, did you get your question answered? Okay. Councilmember Cordero. No? Okay. So, Director, I just have a couple questions for you, and this is just to clarify everything. Let's say, for example, Lena did not get the necessary documentation up front, including licensing and insurance information. Even if the dwelling unit is located in an area where B&Bs and TVUs are permitted, how would you, DPP, prevent the registrant from being issued a permit who does not satisfy the requirements to operate a B&B or TVU?
So I think we are assuming that they are compliant if they're within the zone, and that's as of right, they're able to have that use because they are in that zoned area. And again, we wouldn't ask for that all that registration information. It would be when we have an issue with them, when there's a complaint or we suspect that they aren't compliant for some reason, then we would initiate the investigation and ask for that, and then they could potentially be in violation, and we can enforce upon that. Yeah.
Okay, maybe Lena, would you like to say a few words
yeah.
in response to that question?
Lena Pomsuan, DPP staff planner. So another route that's been happening recently is because we have the new tax classification for short-term rentals that separates them from hotel and resort. We've been seeing that as a trigger as well, to let people know that you need to register or else you're gonna be paying residential taxes or a different type of tax, and you won't be able to do a short-term rental.
Okay, okay, Councilmember Tupola.
Just sorry, one follow-up on the verbiage, since we're gonna try to clean this up with everything. And maybe for you or the director. So it says 1, 2, 3, 4, 5, 6, 7. 7 different times upon the request for DPP of the DPP director. So director, is that what the verbiage that you wanted to say?
So I think in the first part for the new registration, it should be upon request. I think that was the original draft. And then in Councilmember Say's draft, upon renewal, again, we're just reiterating upon request. I mean, I think we could make it even simpler and just say, this is what you should have upon request at registration. And then for renewal, these things should be updated and also should be available upon request by the department.
So you're saying upon the registration, have everything ready. We're going to go through it, maybe, maybe not, but like we're just going to make sure we're good. And then also if there is some type of violation that's been issued or suspected.
Right.
Okay.
And then annual renewal. So annual renewal, same thing, but make sure your documentation is current.
Understood. Okay, thank you, Chair.
Okay, any further questions for the director? If not, thank you very much. At this point in time, we will now proceed with remote testimony. Madam Clerk, do we have any remote testifiers?
Yes, Chair, we have 2 standing by.
Okay. First, Mr. Michael Hay. Michael, are you there?
Yes, Chair, I am here.
Please proceed.
Okay, I'll begin. Well, aloha, Chair, Vice Chair, and committee members. It's very nice to see all you again. I'm Michael Hay. I'm one of the directors for OSTRA, the Oahu Short-Term Rental Alliance, and we strongly support Bill 53 CD1, including the items discussed by Councilmember Tupola and Director Apuna, especially the enforcement against illegal rentals and so on. So we appreciate the zoning chair, the staff, and the DPP for their collaborative efforts in simplifying this TVU registration and renewal. As an owner who went through the initial registration process when Ordinance 22-7 first became law, and then I re-registered recently, I know that this streamlined process will significantly reduce barriers for owners, especially our kapuna, and improve registration numbers. This legislation is a positive step forward and demonstrates the county's commitment to working alongside the community for the benefit of all. Mahalo nui loa.
Thank you very much. Members, any questions for Mr. Michael Hay? If not, thank you very much. Next, we have Ms. Angela Young.
Aloha. Angela Melody Young, testifying on behalf of the peers. So my main concern, I'm wishing to comment with the transient accommodation, is that the laws have too much regulatory burdens that do not allow the accommodations to operate. For example, with the Maui recovery efforts within the resilience action plan being discussed amongst the city and the accommodation to provide shelter and housing for the Maui community. And yet, because of the restrictions, accommodating the Maui community was very difficult because of the laws that restricted the transient accommodations prior to the Maui fire. So the concern, I get it with the transient accommodations to operate as freely as possible is that it causes overcrowding or traffic congestion in certain neighborhoods. And another concern is hotels, that now the accommodations are at a competitive edge with hotels, and it should be not at the level of hotel corporations because hotels should be the dominant market in the tourist industry. And yet that limits the economic potential of small businesses and the community that operates the small businesses of transit accommodation. Also, my concern is preservation of Hawaiian culture. I don't think that the transient accommodation was like bad things that happen to Hawaiian culture. I actually think transient accommodations really support Hawaiian culture because when the tourists go to Hawaii, then they get to live in the transient accommodations and
Ms. Young,
they
your
get to
time
do
has expired. Would you like to summarize your statement in strong support? Okay.
wishing to comment, I'm neutral. I want to
Okay.
just okay. Thank you.
Okay, thank you very much for clarifying it for the chair that your position is neutral on this particular measure. And submitting comments. Okay, great. Members, Madam Clerk, are there any testifiers in person testimony? Okay, Mr. Monaco.
Thank you, Monaco Senior again. I'd like to expand on my previous account and also remind you, in Waianae, we depend on the fishes on our ocean, and also remind you that we are homeless in Waianae. We need homes, but all those homes that they built along our shoreline from Nanakuli to Makaha, we cannot live in them. And we need homes that we can rent out. Those homes are too expensive for us, so please help us. Thank you.
Thank you very much. Any questions for Mr. Monaco? Thank you very much for your in-person testimony. Madam Clerk, are there any future testifiers before us?
Chair, there are none.
Thank you very much. At this point in time, members, we are in discussion. So at this time, the chair would like to then recommend that Bill 53 be amended to the posted committee draft 1 of both incorporating your idea and mine as part of the CD1. No? Okay. It's just in one section. Okay. Why don't I'm going to go with the chair's committee draft, and during the second hearing that we have, we can incorporate the idea that you have proposed.
Yeah, I was going to suggest that. It's minor verbiage, but I'd rather have it written. So we have one more committee hearing, correct, Chair?
Yes.
Thank you.
Okay, so let's start all over again. The chair recommends that Bill 53 of 2023 be amended to the posted committee draft 1. Any discussion, objections, or reservations? Hearing none, the bill has been amended to a committee draft 1. The chair then recommends that Bill 53 of 2023 committee draft 1 be reported out for passage on second reading and scheduling of a public hearing. Any discussion, objections, or reservations? Hearing none, so ordered. The chair then notes that the time needed to consider Bill 53 of 2023 may exceed the current deadline for council action. The chair therefore recommends that the bill be granted a 120-day extension pursuant to the request from the Department of Planning and Permitting in the Departmental Communication 287 of 2024. Is there any discussion, objections, or reservations? Hearing none, this particular measure will be back to the committee for a second hearing. Moving on to agenda number 3, this bill relates to permits. I will defer to Council Chair Waters on this particular measure.
Thank you so much for putting this on today. Basically, I'm trying to give DPP more tools to enforce unscrupulous builders, namely monster homes. Oftentimes when these homes are built, they will make the home look acceptable to the building inspector, and then once they get their notice of occupancy, they'll open up the walls and put in additional kitchens or wet bars and whatnot. So the first thing this bill does, it allows the DPP to get a warrant issued, but first it has to be issued by a judge based on probable cause. The second thing is, what we found is when there are stop work orders, the builders will keep building, and the neighbors don't have any notice of whether or not the builder actually received the stop work order. So what it does is requires the builder to post the stop work order. Similarly, what is required when you're building a home or doing renovations, you have to post your building permit. This simply requires that you also have to post the stop work order. Because oftentimes DPP is low on inspectors and they can't be everywhere all the time. But if the stop work order was posted, the neighbors could see it and call DPP and help in the enforcement. So that's what this bill does, and I look forward to a lively discussion. Thank you.
Okay, thank you very much. May we call upon the Director of Department of Planning and Permitting in regards to Bill 6?
Thank you, Chair. So we appreciate the intent of this bill to better inform the public and to provide authorities to DPP. With regard to the administrative warrant, we do already have this power, and we have used it in the past, but we do it sparingly. It requires probable cause, a higher level of our standard. So we do have this, and we will use it in specific cases where we believe that we can meet that standard. With regard to the notifying the public about building permits, revocations, etc. With all of our technology improvements, we want to be able to provide that information electronically, and that will be part of some of the improvements in the software, etc. Right now, you can go onto our website and put in an address and see some of the information, whether there's a notice of violation, etc. But the new system should provide more complete information. And we just think that that might be the best way. So you can just put in an address and it'll tell you what the status of the property is. I know currently, yes, you must have a building permit posted on your property when you have construction happening. We could potentially put a QR code or something so that people can quickly look at what's happening. But even when I go for a run in my neighborhood and I see there's construction, I look for the building permit in the window, but I don't know if I'd necessarily go up to the window and look at it, and I don't know if that's what the public would do. So I think this bill is an opportunity for us to look more at and discuss how we can inform the public more immediately about certain issues with the property. Thank you.
Okay, Chair, go right ahead. Oh, we got Council Member Dos Santos Tan for a question. Please proceed.
Thank you, Chair. Two questions. So first, both of them deal with the warrant provision. The first question is, what constitutes a proper oath or affirmation? Does this have to be from a building inspector? Can this be from a neighbor? Can this be from an HPD officer? So that's the first question. The second question is, can you walk us through the process of getting a warrant? Does that require DPP to get cooperation from a corporation counsel? How long does this take? Because sometimes timeliness is important, especially during the construction process.
Thank you, Council Member. So we do work with CORE when we need an administrative warrant, and it does go to the court to decide, and there's filings that are involved. I think it depends on the situation. We can ask them to quickly work on that. And then, that's the first question. It
had to do with the oath or affirmation. Where does this come from?
Yeah, so I think it's to establish the probable cause. It could be from the inspector or a neighbor, some witness, or other HPD to provide that information so that the judge can review it and decide whether a warrant can be issued.
Did you get your question answered? Okay. Chair Waters, please.
Thank you. Okay, two lines of questions. First, dealing with the warrant, and then second, dealing with posting of the stop work order. So first, the warrant. You know, in what instances are the building inspectors allowed to enter onto the property, private property?
Right now, upon consent, yeah.
Consent. So if the house is in the middle of being built and there's a permit pending prior to the certificate of occupancy, only by consent they're allowed to enter onto the property?
Pretty much, but I think that's normal. So if there are contractors on site in their building, they normally, of course, would allow inspectors on site to check the different phasing of the work. If there's a violation, I mean, they normally just ask, and I think it's minimal where we're not allowed on property.
So my understanding is, right, the plumbing and the electric wires are behind drywall in often cases. So once the wall's closed up, how do you inspect whether or not it's done properly?
So there's different phasing. So if it's new construction or alterations, et cetera, they have different phasing of inspection. So
Right.
when they, frame, they inspect, and then when they start to rough in some of the stuff, they inspect again before they close things out. So that's the requirement.
Okay, so, I mean, your earlier testimony was that only by consent they're allowed to enter onto the property. But to further clarify, they are allowed onto the property to inspect the plumbing prior to the closing up of the wall, correct?
Right.
So that's not a consent thing, that's required, right?
Yeah, but for them to get the final certificate of occupancy to close out the permit, they would need to have the inspector sign off and approve the work that is being completed.
Yeah, but when does that occur? Because, like I mentioned, you put the drywall up, how do you tell that the plumbing's done properly?
That occurs, so they don't go out just once. They go out at various phases of the construction. So if they haven't, they would have to make sure that the plumbing, et cetera, is correct prior to the drywall, et cetera. And then at the end, if they're not able to show that that's correct, then they wouldn't receive the final approval. The permit would stay open indefinitely, and then until they could provide that information.
So if I'm understanding you correctly, then it would behoove the homeowner or the contractor to consent to the inspector coming on site early and perhaps often, so that when the final walkthrough goes through, they can check off that, okay, the plumbing was done correctly, the electricity was done correctly.
Right.
Yes. Okay. And you say that the DPP already has the authority to get a warrant to inspect where there's probable cause. Where would we find that authority?
In different codes, and I can't recall which ones, like whether it's building or electrical, there is some provisions in enforcement for administrative warrant. And then I think just as a matter of law, we can ask for that. If we have probable cause, we can go to the court and make the case that we need to enter because of this. We believe that there's a violation. So I think we have that authority in general, and we have exercised it in the past.
Okay, if you could provide me and or the committee where this authority exists, because I'm happy to suggest an amendment to delete it if you already have the authority. Okay, next, dealing with the notice of stop work order. So what happened in your former district, council members say, in my new district on Wilhelmina Rise, what happened was the DPP issued a stop work order, but the owner claimed that they never received it. So I'm standing in front of the house while these workers are feverishly putting up a cement wall. When I knew for a fact, because it was on your website, that there is a stop work order, but they were still working. So my staff came up with this idea. Hey, post it right there on the property. That way we can show that they received it. So my question to you, Director, is you agree with me, right, that you have to actually receive the stop work order in order for it to be enforced, right? It's a notice thing. It's a legal thing. It's notice. You actually have to have notice that there is a stop work order, correct?
Yes. Mhm.
So how do you solve the problem that I just explained, where the owner is saying, I never received the stop work order, and these guys were working. I actually had to call the mayor and the managing director to come out and get this thing done, because these people were just, you know which house I'm talking about, right? Those 3 homes, we went through this entire appeal process, and thank you for the good job that you did. We were able to stop them. But, you know, I don't see the problem with requiring them to post it.
Yeah, I mean, I think if that would help, I think that's fine. I mean, once they violate a stop work order, it's like triple penalty. So right there, that would happen. I don't know why I wouldn't heed the stop work order, knowing that it's that much higher. But if it's helpful to the community to post it.
Well, again, in this particular example, the owner was claiming that they never received it. So let me ask you this. What is DPP's policy with a stop work order? Do you get someone out there to deliver it by hand? Do you deliver it by mail? Are they required to come to DPP to pick it up? What happens in these cases?
I believe it's a personal or certified mail, personal delivery or certified mail. And we normally have records of that. So if it's certified mail, we have records about the return receipt.
So if an unscrupulous builder gets a mailman who comes up with certified mail and says, I don't want that.
Mhm.
Where's it from? Looks at, oh, I'm not taking that. Then the stop work order does not go into effect, correct? Because certified mail, you got to sign it saying, hey, I received it. Right?
Potentially, yes, we have that in some violation cases. So in the short-term rental ordinance, they've added in the last amendment that we could, after trying these different ways, we could physically post, and that would be sufficient. And we want to actually duplicate that in our other enforcement areas. And the inspectors like that because, yeah, they can just post it, and then it's clear.
Okay, I think that's even better idea, that your department shows up on the property and conspicuously posts it, right, where everybody can see it. Are you amenable to that? Making that a requirement that your department must go out there and post the stop work order?
Yeah, it's a resource issue. That would be my concern, but and I think, I mean, yeah, I think we'd have to see how much of a resource issue and how we would be able to implement something like that.
I mean, don't you think that's the best way to do it, though, so that it's clear that you don't have to wait for the mail to see if they actually grabbed it, that you go out there and post it? You know, every morning, 8:30, go out there and post them all, right? Then the next morning, you know, I mean, how often are these stop work orders occurring that it's a resource issue? I'd imagine it's not that often, right?
Yeah, I mean, it's not like everyone is working, you know, without permission. Yeah, I think we'd have to look at that, but I mean, that's their obligation too. So how much are we going to shift on DPP to show that what they're supposed to be doing under a stop work order? I mean, we will enforce, like I said, triple penalties, et cetera, to shut them down when we're aware. But I mean, how much is it our responsibility to just stop the work? They should be doing so.
Well, again, it's a notice requirement, right? You need to give the owner notice that there's a stop work order. And unless it's done in person by mail, that's a loophole. So I'm trying to close that loophole. And again, I give you the exact example of what happened on Wilhelmina Rise. They claim they never got the stop work order, and they were working, man. They put up pretty much, I would say, 50 feet of CMU wall and about obviously 6 feet high. 50 feet. Can you imagine? I mean, these guys, in my mind, of course, I could never prove it. I didn't have probable cause. But in my mind, these guys knew the stop work order. That's why they had everybody out there, like 9, 10 guys, feverishly putting up this wall before the stop order occurred. And again, when we called your office and I called the mayor's office and they called the developer, well, we never received the stop work order. The easiest way to combat that is you go post it right there on the property, right? Easy. You're saying it's not easy?
I'm saying that if there's a stop work order and it's in effect, they have to comply with it. And if they're not, they're going to face other enforcement rather than, just the posting of it, that they have to, they're going to have additional fines, et cetera. So in that case, I'm pretty sure that they received it, and there's those really unscrupulous ones that are just gonna say whatever to do what they're gonna do, and we've seen that in that one case all the way to appeal that they believe they're right. And I think that's a minority that they're gonna do that. So I don't know if we need to legislate or have staff do more than that because of these few that are just going to do whatever they want no matter what. So yeah, I mean, and maybe the penalties need to be even higher when you.
Yeah, but it's a notice issue. If the builder doesn't get notice.
That's what they're claiming, right? But they might have gotten.
I'll walk you through it. Mm-hmm. You send a stop work order by certified mail, right? How long does that take? 2-3 days. Probably,
potentially,
right? Mm-hmm. Potentially. So they can still build and still do all kinds of work while we wait for the mail to be delivered, correct? Is that correct or not? They could still do the work if they haven't received it.
If they haven't received that, that's correct.
Yeah,
but I do know.
Could be 2 or 3 days, right?
It could be.
Now, what happens if they are not home? The developer is not home, they're traveling on the mainland, and they don't get the mail, right? What happens then? Does the builder still be allowed to build because they never actually received the certified mail?
That's true. And then but in these.
So how do you solve that problem?
So in certain circumstances where it has been really bad, and we know that this is a developer and I think it was even that one, our chief building inspector, he did go out and tell them, you're under a stop work order. It's just
only after I called the mayor's office, right?
Yeah.
I mean, I literally have to stand there and wait to get this done. Neighbors were so upset, right? And look what ended up happening. They built 3 homes, So to me, it's such a simple fix, right? And it's like you said, it doesn't happen that often. Just go up there and post the stop work order. I don't understand why you're objecting to this.
Well, I think, I think we'd have to look at the rate of when this happens and how much drain on resources this is. It's upsetting when one bad actor can kind of like create all this additional burden or requirements on the department. That's my concern. So we're going to go after the ones that continue to just ignore us, but I'm just being more cognizant of how that affects my department and our ability to do our jobs.
I appreciate that very much, and we don't want to overburden you, but honestly, I don't think this is an overburden. Unless you show me statistics on how often you're issuing stop work orders, right? To me, it's not unreasonable to ask your department to do this. Can you give us how many stop work orders a week do you do?
I'd have to see what that data is.
Yeah, so you're testifying against this without even knowing the data.
Well, I'm just saying I need to look at the data in order to see how we could.
Thank you. I appreciate that very much. Thank you, Chair.
You're welcome. Okay, Councilmember Tupola.
Thank you so much. I have a proposal, and maybe, if Chair Waters is amenable, this might work, because we had a similar issue with the stop work order argument, but there was no place to post the stop work order because to access this person's property was way far, and of course it would be trespassing if we went up and put it over there. Is there any way we can just post it on your website as an additional place? So I do know how to look it up. I know how to look up every TMK and what the stop order, but possibly having it posted in a more public space on your website, then you don't have to go out, and then all of us can refer to that, because he also had, again, not to say that it's the same story, but it went to the wrong address. And so he continued, and then I had to look it up online. I found that it's his stop work order, but we had to somehow convey it to him. So I think maybe in those instances, and I don't know if it could be written in where either there's a trigger or it rises to the level of public, I don't know, because it was like the whole entire neighborhood was mad about it. Is there a way that we can just, for that particular one, post the stop order in a more public place? Kind of like how we have to list certain things in the newspaper. Who knows who reads it, but we listed it. And that's part of the public process, is like, hey, we notified everyone, we put it in the newspaper. So I think your website is actually where a lot of people go. I think the front or the main part of your website would work. I'm not opposed to having another mechanism aside from the letter, seeing as though you guys can't always ensure that the address is correct, that the person is receiving it. So what is your thoughts?
No, I think that's good. We could do something like that on our website. Additionally, we just came up with a map, a GIS map for short-term rental violations, et cetera. So people can just click on a property and it'll give you all the information. And so our staff is developing a similar map for all types of violations. So I think that could help feed into a page that says just for stop work orders, that this is the current.
Especially if it's not that many. If it's not that many, it won't overwhelm your website. It won't take over all the main important parts. But if there's a way, and if it can be kind of prioritized, because I hear what you're saying about the other violations, but these ones are kind of severe. The one in my community was kind of severe, where everybody was talking about, neighborhood boards were talking about it, everyone was fighting about it. So at that point, we have very little recourse. So if that's a possibility, thank you, Chair.
Thank you.
Any further questions? Go right ahead, Chair Waters.
Thank you. I'm very open to that idea, but I mean, you're an attorney. How does posting on your website satisfy the due process requirement?
It doesn't, but it addresses the public notice.
I mean, okay. So the public gets to know about it, but the work continues. I'm trying to address how do we actually get the work to be stopped?
Right.
Right?
Yeah, and it is, again, our building chief will go out and he'll personally deliver it, which is what we do, personal delivery. If we feel that they're trying to avoid the notice, the receiving of the notice. So,
I mean, to me, what was brought up was notice can be satisfied, due process can be satisfied by putting an ad in the paper. Would you prefer that? To me, that's more cumbersome, more expensive, more time consuming than just sending somebody out there and posting it outside. By the way, we put yard signs all the time. Just put them posts, pound them in and staple it to the wood. To me, I mean, it's not rocket science here.
Yeah, but I don't know how it's different than us personally serving it. But you're saying you want it posted so the public can see?
Yeah. And so everybody is on notice, that's how we satisfy the due process. Maybe that's what we need to discuss with the lawyers. By posting it on their property.
What we would like, posting of these notices on the property. Again, the short-term rental and the LUO allows it, but if we could do it for all our other codes to allow our inspectors to post as notice.
Okay, thank you. Thank you, Chair.
Okay, Councilmember Wire, please.
Sorry, just want to make sure. What was the last part you were saying, Director, about, so you would be open to just all violations being able to be posted, or just that last sentence? I wanted to make sure I understood.
Yeah, definitely. So short-term rental, we already have that because we did it back in 22-7, Ordinance 22. So the other inspectors, they want it for other violations outside of LUO, whether it's building, electrical, mechanical, et cetera. So that would be helpful. That's something we were hoping to work on. Ultimately, I'd like all of our enforcement provisions to be centralized into one, because it's kind of all over the place, but it really is the same process. But yes, we would like public posting to serve as sufficient legal notice of a order or violation.
Okay, I appreciate that. And actually really appreciate the map that was created. And I know we talked about like just other types of activities that could be on that. And so I think like as they develop it, I think working towards like a single map, kind of like it has like the overlays and everything, might be really helpful. So folks can just like go to one place and kind of sift through whatever, whatever info they want to find.
Yeah, we're definitely working on that. So we hope to have that, in the next few months.
Okay,
Thank
mahalo.
you.
Okay, any further questions for the director? Director Apuna, just one question. Under what circumstances would DPP issue a temporary certificate of occupancy, which would allow inspectors entry to get the permanent certificate of occupancy? So from a temporary, can the inspectors go in at that point to permanent?
So you're asking if
Yeah,
when
let me
they
start
get
all
ex-
over again.
Mm.
Under what circumstances would DPP issue a temporary certificate of occupancy, which would allow your inspectors entry to get to the permanent certificate of occupancy?
So if the applicant has a TCO, temporary certificate of occupancy, they would still need to have the inspector come in to give the final
Right.
certificate of occupancy. So
No, under what circumstances
Do
can
they get
go
the
in
TCO?
earlier? Okay. So, Tyler's here, yeah, okay. Yeah. Okay. Okay, at this time, I have to appoint, okay, it's fine. Okay,
so are you
Tyler's here also, yeah, okay,
you're asking
Yeah.
under what circumstances
Circumstances.
that you get a TCO?
yeah.
So I
Or
don't know all the specifics, but I guess it's, if as long as you have certain life safety things that are met, but maybe there's something else that you need to do, that we could allow temporary occupancy while you get those final things. I'm sorry, I don't have the details of
Okay.
exactly what those
Okay.
requirements may be.
Well, this is just first reading, second reading, so we're gonna continue on with the discussion, Chair. Thank you very much. Madam Clerk, do we have any remote testimony now?
Chair, there are none.
Okay. Is there anyone standing by, Madam Clerk?
Chair, there are none.
Okay, let's move to in-person testimony. We will now proceed with in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
All right. Is there anyone else here in the council chamber who would like to testify? Please.
Chair, there are none.
Okay, great. Members, so we are in discussion.
Chair,
Yes.
thank you. I'm
Sure.
happy to work with you as well as the director to come up with an amendment that basically helps the department do this and perhaps figure out how often stop work orders even occur. But what I'm hearing from the department is that they want the ability to satisfy the notice requirement by putting not only this stop work order notice, but others at the property. So with your indulgence, if you will suggest passing this out and in between second and third reading when this comes back to your committee, I'm happy to work on a committee draft. Thank you.
Please proceed with the department in working it out, the draft. I have one question for the Corporation Council. This is a question that may be out of line, but because I think all 9 members of the council do public service, could you deputize us to go deliver those notice of stop work orders?
I don't think there's a required to be deputized so long as the director, I guess. I don't know if the word's deputized gives you authority to do that, but anybody can serve the notice. By the way, with respect to posting, the ordinance does allow posting, but you got to do the first two. You got to at least attempt the first two first, certified mail, personal delivery. So, and then if you can't do that, then you can post. So there is a posting, but you still got to do the first two first.
Okay, thank you. Would Director Apuna, would you be, I think you'd be honored if 9 of the council members were given the opportunity of putting up those stop work orders in their particular districts.
I'm sorry, if who did the,
Since we're having a difficult time in getting these posting of the stop work order, I'll be happy to go and post it up for you folks.
Okay, thank
Other
you.
council members as public service. I don't know. I just bring this up. You know, we live in a district that we represent. We live in a district that we try to represent our constituency. So I just thought, wouldn't it be proper that if we can do it, and that's the question I'm posing to you.
Chair.
If can or cannot, that's all.
yeah.
Yeah.
I will say that in the building and the zoning code, it already has a section called authorized personnel. And under authorized personnel, the building inspector can actually give directive to who the building inspector chooses, but I'm not saying it's us, but I do believe there's some verbiage there that allows for the building inspector to authorize personnel. I think it's referring to more like police officers, but
Yeah, and we can, I think it's an ordinance or statute that we can have HPD help to serve the order if they're not complying with it.
Okay, it's just that I thought, since we live in the district, we know where the monster homes are, we could do as far as putting up those stop work orders. I don't know if it's a placard or a sign. Is it? I don't know. But, okay, it's a piece of paper that's laminated, so, okay. Maybe I'll try it one day. Okay, Chair Waters.
Can I ask Corp Counsel a question?
Oh, yep, Mr. Pang.
Thank you so much. You testified that DPP is first required to attempt certified mail and or personal service. Where do we find that requirement?
I just saw it.
Because perhaps that's where we need to amend.
21-2.150-2C2, director may serve an enforcement notice at the violator's residence, place of employment, or usual place of business by physically posting the notice, provided due diligence was used in attempting to serve the person personally or by registered mail. So you kind of got to do the first two first, or at least attempt to do the first two.
Right.
That's how I read it. Yeah.
Okay, so perhaps we should look at amending 21-2.150-2C2 to say that you satisfy the requirement by simply posting it. Yeah?
Yeah, I mean, the language is the language right now.
Right.
It's up to you.
Yeah.
Yeah.
Terrific. Thank you. Thank you, Chair.
Thank you. Thank you very much, Mr. Pang. Any further discussion, members? If not, the chair would like to recommend that Bill 6 of 2024 be reported out for passage on second reading and scheduling of a public hearing. Any discussion, objections, or reservations? Hearing none, so ordered. Moving on to agenda number 4, Bill 10 of 2024. This bill relates to building permits. This bill would remove the affidavit requirements for building permit applications. The bill would also require additional plan review fee if a building permit applications need to be resubmitted for failure to include necessary information in the initial application submission. Members, we have posted to the agenda a proposed committee draft 1 version of the bill. For your information, a summary of the amendments is listed on the agenda. At this time, I'll defer to Councilmember Tupola to explain her committee draft 1.
Thank you so much, Chair. Yeah, as you stated, there's just two portions of this. There's the affidavit portion, and then there is the part that is proposing that we impose fees when people have to resubmit. So my version is striking out the fee portion because I do believe that we provide public service, which also includes education. It includes repetitiveness. It includes us trying to get the public to better understand our processes, but we are not a private agency or business where I feel like we should start to have punitive fees on top of people trying to resubmit. I do think the DPP is getting better at giving people what the parameters of what the applications look like, as they've done with the pre-screen process and now with their new software. So it may be resolved there, but I will say that there's lots of opposition to applying a fee to people reapplying. So I struck that out in my version. Thank you.
Okay. Any questions, members, at this point in time? Director, would you like to respond to the council members' amendments in regards to the waiving of the fees for a resubmittal, which was an error by the applicant? The error, Councilmember Tupola, is the applicant and not the department. So that's double work. But I'm not trying to defend the department, but please.
No, yeah, we appreciate Councilmember Tupola's comments and concerns with that, the plan review fee. So the plan review fee is to support the review by DPP, and if you have some good quality plans, it should be one review cycle, maybe two. But when we have ones that are like 4 or 5 review cycles, we want to encourage better submissions. And from what I understand, even Maui, they have an additional fee for any additional review cycles. A big part of what will help to streamline and make the permitting process to go faster is to ensure that the quality of plans are good. And so this is one way to make sure that people understand that it is more time, effort, review cycles if they don't provide good quality plans. So that's my comment. But I mean, I understand that we're kind of in transition now and trying to get things, educate the public, et cetera. But that is something that we would like to be able to consider as far as changing the behavior on the outside to also improve what they're doing with their building permit applications.
Okay.
Can I comment, Chair?
Please go right ahead.
I hear what you're saying, Director. I think for the few applicants that I've helped within my district that have had issues, and some of them have very high quality contractors, architects going through this. I saw their plans. I saw their timeline of how much back and forth they went through with the department. I saw many of them submit the SAI, meaning that they paid more to see if they could expedite it, and they still had to wait 1.5 years. I feel like the punitive part of the process is if you don't submit it, then it takes longer. You do a good job, then you get it faster. And I'm not saying that they did a junk job or a good job. I'm saying that what I've seen from issue to issue is that every time I've reviewed the issue with the applicant and the particular person at DPP, there are some times, not all the time, there are some times where what they are asking or what they're requiring is actually not in the law. It is not required that a certain paint color be used or this, but the person who's reviewing their application wants them to revise a certain part, of which I've jumped in a couple times and said, hey, can we please stick to the law because this particular application did not require that. And I don't expect you to go through all of these, right? This is at the code review level. So I guess my issue with coming towards, and I see that the goal you're trying to get to, and I admire that goal, is that if the software is better, whereby you guys have very specific things that they submit where there is no deterrence out of what's required for a basic application, then that will suffice. I just still feel like you guys are in a transitionary period where there are small handfuls of people's applications that are derating a long time because of personality differences in perceiving what the applicant should have done versus what they did, even though that was not required in the law. It was not outlined, but they want them to modify the application to meet this, whatever it is. And I can go through each one, but that's where I stand in the gray area, is we go towards a punitive approach when there is already a very punitive thing happening right now, which is the length of the time it takes to get a permit. To me, that's punitive. So I feel like that's what happens when it doesn't work. And until we are just popping out permits like within 60 days and now people are really bogging us down, I don't know if we, on top of the length of time of a permit, that now a fee will then encourage them to even better do it. So I guess that's just my perspective.
Yeah, I appreciate that. I think there's different things going on here. So there's, I think for more complex commercial jobs, there is going to be relatively more reviews than like a residential, a simpler project. But there are those, and I understand we're working with staff and providing more consistency in review, making sure that it is based on something that is objectively clear to the applicant and the reviewer. But there are those, and it's not a minority, it's a pretty good chunk of them that, again, it's like 3, 4, 5 reviews and they won't answer comments. Like we want them to take it more seriously. And I do truly believe that if people took more time to really put in good plans from the get-go, not all of them, but this chunk, and they were motivated to do that their times would come down, and so would others who are forced to wait because we're working on continually addressing comments on certain plans. So I understand. I think your point is valid, but I think there's a lot of things going on here. And at some point, people on the outside also have to kind of fix things. Tomorrow we'll provide some more information about the AI that we're working with. We're in beta testing, and they've already given us really good data. Like, it tells you exactly what the greatest issue is with residential new alterations and additions. Like, we can say, like, 65%, they're missing this one thing, and 30% are missing this. And so that's huge because we can focus on that. We can tell the applicant, you're supposed to provide this information, et cetera. So like I said, yeah, transitionally, we're trying to figure out how we can let them know exactly what the standard is, and we're all on the same page. So I understand that. I think it's just, there is this kind of hidden thing where, you know, people think their permit's in for 2 years with DPP, but it is not sitting for 2 straight years with us, right? It's the back and forth, it's the other agencies. So we want to kind of bring light to how people can help out in making the process better too, not just DPP, you know, trying to fix everything. We are doing that, but I think that on the applicant side, there can be better work coming in.
Are you guys still using E-plans and Posse?
Yes. Yeah.
So I would argue that until we get out of that we are not going to get better. I have seen the breakdown of interface between Posse and E-plans. I have seen how comments have to be transferred to a certain person, and then once they're transferred, then they can respond. So I believe that this new software is going to help. I believe that by having an AI, you know, respond to things that have to be corrected, that will also help so that you guys don't have to manually go through that. But I would argue that until we get to that point where we have a seamless, congruent system, I still feel like there is some of it where, yes, on our end, because we're providing a public service to the public and trying to help them, that we do have to go through this educational component. And I would argue that possibly for one component, right, of what you guys are doing is educational courses on how to do it. So like I've talked to you previously about us offering courses, like maybe taking a pre-course, like an actual 20 to 30 minute course that you would have to watch prior to even applying, because then you're really providing the education and not just assuming that they knew all of these things already. Many of them are first-time applicants that are trying to learn the system, and God forbid they don't have an architect degree or, you know, electrical degree, and they make a mistake. Like, I mean, I think that once those educational pieces are put in and the software is seamless and we know that we are operating very efficiently, like getting a punitive fine on top of everything else you're going through. And I hear you that it's not sitting, they need to respond back, of which many people I've talked to are like, oh, I didn't even know that it was back in my QE and I had to respond. And so there is a little bit of education there where I think you guys, your website's getting better, but do you have a video that people watch prior to applying?
We have some checklists, some information on our website about what they need to do, say for the pre-screen, et cetera. But that's definitely something we're building out. The education on the outside, that's like 50%, again, of them understanding that the AI that we're using, it's not just that the computer is checking, it's like guided review. So the applicant becomes more educated about what is required. So that kind of speaks to what you're looking for, and that's what's really going to be exciting, because it's going to educate the applicant and our staff. It's going to point directly, like, you need to cover this or that.
And when
So-
would that be implemented, what you're speaking of?
So that is, we're currently in a pilot program that is 5 months. We're like 3 months in, but we want to be able to extend that and have them, they're focusing just on residential. We want them to do that for mechanical and building, electrical, for commercial, everything. So it's going to help to provide that guided educational element, as well as us wanting to provide more videos, et cetera, on our website, or even some Zoom calls so everyone knows, like, that you're kind of hitting it on the head. Like, people don't understand what the requirements are. I do feel they need to, if they have a license, that we should hold them to a certain standard. But yes, we should have that information as well, so that everyone is on the same page.
Yeah, I would say if you're not opposed to it, I think once you guys go through your pilot launch and once that's implemented, we have videos that are educating people, and we're differentiating between people with licenses and people without, who really just need the step-by-step guidance. We're opening up Zoom calls to do, like, troubleshooting, or you just call if you're like, I'm stuck, can someone help me? And they might not be the plan reviewer, but they're like, okay, this is where you're at, open this screen, do this thing. So I would say until we get to that point, I think holding off on this will encourage people to know that these educational pieces are out there, and maybe we can revisit this once we still have stragglers. That's just a thought, Chair, so thank you.
No, I believe during the past years, right, we've had discussion in regards to sometimes the professionals do not follow up on behalf of the homeowners, meaning the applicants do not follow up with the department, and where the department gets the criticism as far as the delays. Okay. Any further discussion, members, for the director? If not, yes, please.
Chair, if I may, so I believe on page 3 at the very bottom, there was language that was deleted, and we had this conversation prior. Councilmember Dos Santos Tan had also mentioned it. The last line that's been deleted under subsection 12, no permit application will be accepted or processed if the owner has any such outstanding fines or liens, provided that a permit application will be accepted and processed if it is to correct a violation on the zoning lot. We would like to keep that language in the bill.
Okay, we'll take a look at it.
Thank you.
Thank you. At this time, let's proceed on to the remote testimony. Madam Clerk, are there any remote testifiers?
Chair, there are none.
Thank you very much. We'll now proceed with in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay, members, we are now in discussion.
Chair.
Yes, Councilmember Tupola.
Yeah, I also think that the part that the director pointed out was actually a very recent law change that we had regarding people who had violations that were still getting permits. So I think it's important for us to put that back in. And I just wanted to encourage, yourself and the committee to consider that as we go through transitions with DPP, and they're improving leaps and bounds, that until this system is actually solidified and we're off of POSI and E-plans, we really need to be mindful that there is a learning curve happening right now with a lot of our permittees, and we don't want to increase this burden on people that are trying to work well with the city. So it is still my recommendation that we shouldn't get to the point of fining people for a second review.
Okay, your point is very much well taken. We'll take it under advisement at this point in time. Director, your thoughts? Would you want the fee in or you want the fee out? That's a question that Tupola is proposing to the chair at this point in time. I'm of the opinion I'd like to have the fee in place. At what level, I really don't know. But as far as what is a minor discrepancy versus a major discrepancy. But sometimes if you have any of your plan reviewers here to share with us their experiences.
I don't have any with me today, but yeah, maybe it's just to refine it a little. Like, we want to incentivize or motivate those that are in that certain category where they're not, it's that they're just not being careful with their plans or not reading our comments. I think that would need to be kind of looked at more carefully. If there's a certain type of applicant that is just really not being helpful, and we're kind of having to design their plans or have excessive reviews. Maybe that might be the solution.
Some language of that sort. Okay. Because earlier this past years, right, the discussion was that they want your plan reviewers to do all of their work sometimes in correcting the mistakes. And that's not fair. And that's just, increases the caseload on behalf of your employees.
Right, yeah.
So I just bring this up for discussion because it is a concern that, we shouldn't be looking at blame on both sides, but if there is a pattern, that pattern should be documented so that it could become part of the overall justification for the fee increase. That's all. Okay, members, any? Okay, at this point in time, the chair would like to recommend that Bill 10 of 2024 be reported out for passage on second reading and scheduling of a public hearing. And Councilmember Tupola, you can come up with your, deletion of the fee once more, but we'll have further discussion on it. Yes.
I do like the idea of just changing the verbiage, because I think if we're not applying it across the board and we're being fair to people who are first timers, then I think it's reasonable.
Yeah, and that's where we can have it as far as the second hearing. So any discussions, objections, or reservations? Hearing none, so ordered. Moving on to page 12, agenda number 5, Bill 3 of 2024. This bill relates to incentives for the construction of affordable rental housing. Members, we have posted to the agenda 2 proposed committee draft 1 versions of the bill. Councilmember Dos Santos Tam proposed the first committee draft 1, and I propose the other committee draft 1. For your information, summaries of the amendments are listed on the agenda. I'll now defer to Councilmember Dos Santos Tam to explain his committee draft 1.
Thank you, Chair, for the opportunity to explain. I'll note that all of the amendments that I'm proposing are posted on the agenda. I'll also note that in case my internet cuts out, you can consider it voluntary so we don't have to suspend the meeting.
Okay. For the chair, the proposed committee draft 1 would try to streamline the application process to apply for and receive post-construction grants, increase the grant amounts, modify the reporting requirements, and add penalty provisions. The committee draft 1 would also remove pre-construction financing provisions, which we plan to consider in a separate bill. Director Apuna.
Thank you, Chair. The department is supportive of grants that will help to spur more Bill 7 projects. A couple of comments that we have. So in the Council Member Dos Santos Tam's draft, we would like to not include special assignment inspection as the approval. And then from the change in the law from square footage to number of units, so you get a grant per unit versus square footage. I've been speaking to some of the Bill 7 developers. I do have a concern that it would amount to a lot of micro units, or the smallest size of the unit to get the greatest number of units, and therefore the greater number of grants. And so I know that there is a certain calculus that's involved in order to make a project pencil, and that the market may actually dictate a variety of unit types, but I think a discussion would be great about that, and whether just having a 300 square foot minimum and it per unit, that if there's maybe some way to just be more, some way to ensure that there's more variety of units, even if it is just studio and 1 bedrooms. But that's just something that we should think about. And then additionally, just the administrative burden to DPP there will be additional burden in order to implement the construction grant, and just wanted to make you aware of that. Thank you.
Okay. Okay, members, any questions? Hearing none, let's move on. Madam Clerk, are there any remote testimony?
Chair, there are none.
Thank you very much. We will now proceed on with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Great. Members, we are in discussion. If there is no discussion, the chair recommends that Bill 3 be amended to the posted committee draft 1 that I had introduced. Okay, any discussion? Any objections or reservations? Hearing none, the bill has been amended to the committee draft 1. The chair then recommends that Bill 3, 2024, committee draft 1 be reported out for passage on second reading and scheduling of a public hearing. Any discussion? Any objections or reservations? Hearing none, so ordered. Let's move on to agenda number 6, Resolution 24-95. This resolution grants a special management area major permit to Luamoku Group, LLC, to allow for the construction of a new 2-story single-family detached dwelling with an attached 2-car garage and 2 lanai areas, and an in-ground swimming pool and spa with equipment enclosure and other improvements including entry walls, fences, a trellis, driveway pavers with permeable grass joints, and landscaping on an approximately 17,171 square foot shoreline lot zone R10 residential district located at 1318 Mokulua Drive in Kailua and identified as tax map key 4-3-004:076. Members, we have listed on the agenda addendum a proposed committee draft 1 version of the resolution. For your information, a summary of the amendments is listed on the agenda addendum. Joining us in the council chambers, Mr. Jim Hayes from Planning Solutions, the applicant's agent, who will be providing a brief presentation. And for your information, the presentation is available online as Miscellaneous Communication 196 of 2024. Okay, Mr. Hayes.
Thank you, Chair. This is a residential project in Lanikai. I have an aerial photograph here. It's part of the presentation. It's a pretty standard lot in Lanikai. Similar development around it. Zoned R10, as you mentioned. This is a photograph taken from a drone over the water looking back at the project site. And as you can see, properties in that area all have seawalls along the shoreline. This project site is no different. It was previously developed as a single-family residence, but is currently vacant. The former residence was removed in the, I guess, 20-teens. So the proposal now is to build a new single-family residence. And this drawing shows the original proposal as submitted to the Department of Planning and Permitting. And it included a new residence, single-family residence with a swimming pool and a 40-foot setback from the sea, from the shoreline, the certified shoreline, which is the face of the sea wall. We were in consultation with DPP following the submittal of the application, and it was decided that a revised plan be submitted to address some of the concerns of the Department of Planning and Permitting. That's this slide here that shows the residents moved back to roughly a 68-foot setback. That setback still allowed for the general concept of the single-family residence to be sited on the property. One of the things that the owner was specifically interested in was to have a atrium area between the residence and the roadway, so kind of behind the trade winds, and that's a typical layout for development in the Lanikai area. Since then, we have received the draft resolution, and in that resolution, there is condition E1B, and E1A, sorry. In E1A, it specifically says that the house, the proposed development, should be set back even further from the shoreline. And so this drawing illustrates how that might be. And it shows that if we just simply move the proposed residence back, then the garage will be in the yard area. And so doing this will require a substantial redesign of the project. So the redesign may involve moving some of the space that was originally planned to be at the ground level to be moved to a second level. There was already a second level part. The second level part may become larger at this point. The pool will also likely be downsized or eliminated. The redesign will comply with LUO standards and the information provided as required in Condition B of the resolution. Condition B being that things like impervious surface and floor area ratio and all those kind of things that are specified in the land use ordinance are complied with. And given the large now backyard between the residence and the shoreline, those LUO standards are going to be easy to comply with. Then condition E1B is about the foundation of the development components that are in sort of still on the near shoreline area, relatively near shoreline area of the proposal. And that condition will also be complied with as part of the redesign. And this graphic shows an example of how that might be addressed with the foundation elements becoming deeper, and that the depth of those foundation elements will be sufficient in the event that the seawall is lost and shoreline erosion progresses, that the development will not become compromised. So I think that's the end. Yep, that's the end of our presentation, and we thank you very much for the consideration of this development proposal.
Thank you very much. Okay, Councilmember Kiaina.
Thank you, Chair. Thank you for the applicant and you guys' team, as well as to DPP for speaking with me and my staff so that I could get a better understanding of the coastal erosion provisions recommended for this permit. When we passed Ordinance 23-4, which updated the special management area provisions of the ROH, we required the city to minimize, whenever reasonable, risk to development from sea level rise and other coastal hazards, which may be accomplished by siting habitable structures outside of the sea level rise exposure area if feasible, or if not feasible, adapting a habitable structures within the sea level rise exposure area to accommodate sea level rise. I understand, as you have noted, that DPP is recommending all structures be relocated Mauka of the 2-foot sea level rise exposure area coastal erosion line to minimize risk, consistent with the ordinance. And I also understand that in assessing the reasonableness of the requirement, DPP refrained from requiring the structures to be Mauka of the 3.2-foot sea level rise exposure area. Many of you know who come with SMAs when it comes to swimming pools, of course, close to the shoreline, especially in Kailua and Lanikai. I am going to bring up the issue of iwi kupuna. So my question to you is, if iwi kupuna are discovered during excavation for the swimming pool, is your team prepared to look at alternatives to allow for burial in place, including moving the pool to a different location?
Yes, we just received a letter from the State Historic Preservation Division yesterday afternoon requesting that we do an archaeological inventory survey with subsurface testing in advance of a building permit being awarded, and the applicant will be complying with that request and is understanding of the conditions in the resolution and is willing to consider revising the project in the event that iwi kupuna are encountered as part of the AIS process.
Thank you so much. You know, a lot depends on the area, right? But so sometimes it could be accommodated, but sometimes it could be significant. And so it all depends on the size. As you know, the city is undertaking with the Department of Transportation Service a major project, the Kalapawai Roundabout project, and it's been paused several times. And one of the reasons people don't realize is that EV kupuna have been found, and unlike other areas, it's quite significant. The find was intact, wholly intact, which is very unusual. And so out of just respect and for our EV kupuna as well as compliance with state laws, we just do appreciate you guys are very active in the area with a lot of SMA projects, but we do appreciate any applicant's team to be quite sensitive of this. So thank you so much.
Okay, any further questions for Mr. Hayes? Mr. Hayes, I have a question on the resolution, which is on page 9, and the permits. Okay, the letter K, 1 and 2. So number 1 was pursuant to the ROA Chapter 26 to rely on the 40-foot shoreline setback that is in effect through June 30th, 2024. The project's building permit application must be accepted as complete for processing by DPP no later than June 30th of 2024. Can you comply with that request, since you just stated for the record that you have to do an archaeological assessment first?
We are preparing the redesign of the project, and is anticipated that the plans for a building permit will be submitted, enable a time to comply with that K condition.
Yes.
The archaeological inventory survey doesn't need to be completed until the building permit is awarded, so it can be in parallel with the building permit process.
Thank you. Got it. Just for the clarification. Members, any other questions? No? Okay. Thank you very much, Mr. Hayes. The Department, Planning and Permitting?
Good morning, Chair and committee members. I'm Elizabeth Krieger, the Department of Planning and Permitting for the Director. We support the proposed CD1 for this project, and we're available for any questions you have.
Okay. Members, any questions for the Department? All right. Let's move on then to remote testimony. Madam Clerk, do we have any remote testifiers?
Chair, there are none.
Okay, thank you very much. Do we have any in-person testifiers?
Chair, there are none.
Great, thank you. Members, we are now in discussion. Okay, if there is no discussion, the chair would like to recommend that Resolution 24-95 be amended to the committee draft 1 listed on the agenda addendum. Any discussion, objections, or reservations? Hearing none, the resolution has been amended to a committee draft 1. The chair then recommends that Resolution 24-95, committee draft 1, be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Thank you very much, Mr. Hayes. Moving on to agenda number 7, Resolution 24-110, and this resolution grants another special management area major permit to Jennifer Carver McLennan and John McLennan to allow for the demolition of an existing single-family dwelling and carport and the construction of a new single-family detached dwelling with an attached accessory dwelling unit, an in-ground swimming pool and spa, and a 2-car garage and storage structure on an approximately 19,845 square foot shoreline lot zone R10 residential district located at 44-421 Kaneohe Bay Drive in Kaneohe and identified as tax map key 4-4-006:018. Members, we have posted to the agenda a proposed committee draft 1 version of the resolution, and for your information, a summary of the amendments is listed on the agenda. Joining us in the council chamber is Mr. Mark Howland from Whale Environmental Services, LLC, the applicant's agent, who will be providing a brief presentation And for your information, the presentation is available online as Miscellaneous Communication 191-2024. Mr. Howland.
Good morning, Council Say and councilors. Thank you for hearing me today. This is Jennifer Carver McCullen and John McCullen's property in Kaneohe off of Kaneohe Bay Drive. This is the last final steps of a basically 2-year project. We thank DPP in particular for the thoroughness and carefulness in the work with us to get the project to the point it is. It was a lot of work on their part. And you all are at the last stages of evaluation, which we appreciate. The CD1 resolutions that have been put in, we agree with them. I wonder why it's not showing. It's on this flash drive too.
Mr. Howland? Okay, there you go.
It's a very steep property from Kaneohe Bay Drive down to the waterfront. Historically, this is one of the projects that Kaneohe Ranch and the U.S. Marines built that seawall that extends pretty much the length of Kaneohe Bay Drive. They eradicated, during the dredging of the harbor, probably around 20 or 30 historic fish ponds, of which one of them was immediately below this property. The proposed action is the construction of a single-family residence on the property. There is an existing dwelling, and the new house replaces that. There are foundation issues, a very severe technical structural foundation examination was done, of which there were several borings to make sure that the new house does not affect by the structural poorness of the soils. And at that point, there were so many borings done that if EV had been discovered, it would have been done. But again, we always agree to the provision that Susan Lebo states to make sure that in the event anything's discovered, work immediately stops and Shepherd contact. Nick Butterbaum of Kailua is the architect on the project. This is the existing property as it is now. As I said, structures outside the shoreline setback, it's set way up on the upper portions of the site. The shoreline is not being affected at all. There's no work proposed. We did work with the shoreline people at Land and Natural Resources, and a dock that was not licensed was removed. As you can see, it's in the SMA. That little square you see down the bottom above the site is the wastewater pumping station. So it's adjacent to that. So this is the proposed plan. Besides the technical structural components of the project, we've also tried to ensure that any view planes down to the water are maintained. So as you can see, the lower areas of the pool and the atrium are in the existing view plane, so that's maintained. It was one of the concerns of the neighbor, and we've tried to address that. This is the plot map, as you can see, it's immediately adjacent to the wastewater pumping station. The sewer line easement runs through the shoreline setback area. This is the shoreline setback map. Basically, it's, again, the base of that seawall that runs up the entire length of Kaneohe Bay Drive. It's been removed in some portions, but it was built in 1939 for World War II. This is the sea level exposure area, the 3.2 feet. As you can see where the red balloon is of the site, very little intrusion onto the property, unlike some further to the east. This is the coastal erosion and vegetation line does not exist for this area, has not been studied. Most of Kaneohe Harbor has not been studied. Again, this is the annual high wave, which does not reach the property at all. This is the Category 4 for the National Hurricane Center, the most severe hurricane surge possible. As you can see where the black circle is of the site. Unlike many other areas in this region, it's not affected as much by hurricane surge. This is the soils. As you can see, it's not jack of sands like common to many other areas in this region. This is basically volcanic alluvial soils, which is one of the reasons why they had to do a very strong structural foundation analysis because of those soils. So again, we're out of Kuku. This is a local person who owns this. They're selling it to another local person who lives in Kailua. The contingent of the sale is based on the SMA approval. So that's why we're here. Again, this is the aerial view of the property. As you can see, the vast lawn is down by the shoreline. The existing house is there now, marked existing house, will be demolished and a new home put in that place. The carport over by where the cars are would be changed to a garage. And again, there's no effect to the pumping station, the sewer line, or the shoreline. So we're open to any questions you have. Thank you.
Thank you very much, Mr. Howland. Councilmember Cordero?
Thank you, Chair. Thank you very much for the presentation. Always great to see you here before us. My question is in relation to, first off, the view planes that you are addressing with the neighbor. Could you explain a little bit which issue you were addressing?
So currently, right now, between the carport and the existing house is the only view plane those neighbors have. You cannot see the shoreline from Kaneohe Bay Drive itself. The only people affected by the view plane are the neighbors who are above them. Currently, right now, there's a lot of vegetation on the shoreline. It's not that great of a view of the shoreline. And of that shoreline, the wastewater pumping station takes up half of it. So you can't see through that anyway. But we wanted to address it, and they were also concerned about the structural strength, which is the reason why you'll see in the original application there's a very detailed technical structural report, because they have the same issues with cracking and foundation shifting and things like that. So by stabilizing this site, it will help the upper site. And then by putting the pool and the entranceway between the new garage and the new house, that same view plane that they had before will still be there.
Okay, I see what you're saying. And I also understand that, so you said the wastewater pumping station is going to be, you're focusing on the infrastructure of that to make the foundation of the rest of the house, or?
No, we're just noting that it's there, and it affects the view plane. The house is pretty far away from it. That pumping station is inside the shoreline setback.
Okay, understood. And as it relates to the swimming pool, are they both on the same level, plane level of the wastewater pumping station?
They're much higher, actually, because the wastewater treatment plant's down. There's almost probably a 60 or 70 foot elevation shift on this property. So it's a steep hillside. So it's something where that house up at the top is going to be overlooking the roofs of everything because it's so high above But we're trying to maintain the viewpoint to the little bit of water that it's able to be seen outside the fact that there's a lot of ironwood and other trees there, so.
And then we can see in the map here that where the wastewater pumping station is located, that there are more, I guess, land that juts out from underneath where the wastewater pumping station is located, right? It's not just cliff, yeah?
It's just a seawall there,
Just a seawall.
yeah.
Okay, and how far out does the seawall go there?
It's like a matter of a few feet. It's not very, they don't have
Matter-
much of a backyard, if that's what you're asking.
No. For the wastewater pumping station.
Right.
Because on the map, it looks like, where the square that you mentioned,
Right.
it shows that there's possibly more shoreline that's further out from it. You know what I mean?
Well, behind the wastewater treatment plant,
Yeah.
that's not my client's property.
Okay.
So they didn't do the shoreline extending, but it's the same seawall. That seawall runs all the way from the base of Kaneohe Bay Drive all the way up to the marine base.
Okay. My next question, I'm sure you're very used to this question, in relation to the swimming pool, is if iwi kupuna are discovered during the excavation for the swimming pool, is your team prepared to look at alternatives, or have you already looked at alternatives to allow for the burial in place, and also the option for moving the pool to a different location if iwi kupuna are discovered?
Yes, we've discussed this with Shepard, and it's understood. The pool's actually, there's an existing pool on the property. The new pool's where the existing pool is, so there'll be very little change.
Are there any changes to depth of the pool?
No, I believe not.
Okay, good to know. Thank you very much. Thank you, Chair.
Thank you very much. Councilmember Wire, any questions? If not, thank you very much, Mr. Howland. Liz, Don, DPP.
Thank you, Chair. The DPP supports the CD1 for this project, and we're available for any questions.
Thank you very much for your very thorough report that you sent all of us. Thank you. Members, any questions for the department? If not, Madam Clerk, are there any remote testifiers?
Chair, there are none.
Thank you. Are there any in-person testifiers?
Chair, there are none.
Okay, members, we are in discussion. Any discussion on 2410, resolution 110? If not, the chair would like to recommend that 24-110 be amended to the posted committee draft 1. Any discussion, objections, or reservations? Hearing none, the resolution has been amended to a committee draft 1. The chair then recommends that the resolution 21-110 committee draft 1 be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Thank you very much, Mr. Holland. Okay, thank you. Okay, let's move on to agenda number 8. Resolution 24-96. This resolution directs the Department of Planning and Permitting Director to process a proposed land use ordinance amendment relating to screening or buffering requirements. Members, the bill attached to the resolution as Exhibit A proposes to amend the Land Use Ordinance, Section 21-4.70-1, which provides that any use located in a B1, B2, or BMX4 zoning district and any use located in the BMX3 zoning district, other than detached dwellings and multifamily dwellings, are required to be screened from any adjacent zoning lot in a residential, apartment, or apartment mixed-use zoning district by a landscape area not less than 5 feet in width along the side and rear property lines, and requires that the landscape area include a screening hedge not less than 42 inches in height. These screening and buffering requirements may be burdensome and not necessary if the common property line with an adjacent zoning lot in the residential, apartment, or apartment use zoning district consists of only a portion of the entire side or real property line of the zoning lot in the business or business mixed-use zoning district. The proposed amendments would only require a zoning lot in the business or business mixed-use zoning district to be screened if the common property line with a zoning lot in the residential, apartment, or apartment mixed-use zoning district comprises more than 75% of the entire length of the side or real property line of the zoning lot in the business or business mixed-use zoning district. If this resolution is adopted by the council, the proposed land use or LUO amendment will be transmitted to the DPP and the Planning Commission for their review and recommendation. At this time, we have Director Apuna.
Thank you, Chair. We will process the proposal as directed under the resolution and provide a report to council. Thank you.
Okay. Members, any questions for the director? If not, okay, just one question. For this particular issue, there is the issue in regards to some conflict between our codes. Is there any other alternatives in trying to address this particular issue that is before us?
Yeah, actually, I think a cursory review of this would probably not address the issue that's presented. So it would probably require a different method to fix the situation.
Okay, or the other thought would be, do we run the course of passing it out and letting DPP and the Planning Commission make that determination?
Yeah, I think that if we provide a report, then the council can decide at that point how they'd like to proceed.
Okay.
Right? Yeah.
Okay, though. Any other questions, members, at this point in time? Madam Clerk, are there any remote testifiers?
Chair, there are none.
Thank you. Now we'll proceed with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay. Members, we are now in discussion. Any discussion? Any objections or reservations or what? Okay, so at this point, members, the chair would like to recommend that action on resolution 24-96 be postponed to a time and date to be determined by the committee chair. So any discussion, objections, or reservations? If not, hearing none, so ordered. And that concludes our hearing for today. To all of you, there being no further business, the meeting is adjourned. Happy May Day to all of you.